This is the third part of my video lecture on the topic of disposition of property by testamentary succession, that is wills. Now we will see the meaning of some important terms, that is words. First word is testator. Testator means a person who makes the will. He is the person whose property is to be disposed of after his death in accordance with the directions specified under the will. Then the meaning of legatee. Legatee means beneficiary of will. Legatee means beneficiary of will. It means a person to whom the property will pass under the will. He is the person to whom the property of the testator will be bequeathed under the will. Bequeathed. Meaning of bequeath. It is a verb. It means the act of making bequest. Bequest. Meaning of bequest. Bequest means legacy. Legacy. It means the property or benefits which flow under the will from the testator's estate to the beneficiary. For example, Mr. A makes a will, and by his will he gives his house property to Mr. B. So here Mr. A is the testator, Mr. B is the legatee, and that house property is known as bequest. Witnesses. The person who are the eyewitnesses of the fact of signing the will by the testator. Fact of signing the will by the testator. Testator means person who makes will, who execute the will. For execution he has to sign the will, and the person who are the witnesses to this fact is known as witnesses. Then executor, executor of the will. The person who would administer the estate of the testator after his death in accordance with the provisions or directions under the will. So after the death of the testator, someone is needed for the execution of that will. Someone is needed for completing the task of execution of that will. So executor is the person who will do that work. So executor will administer the estate of the testator in accordance with the directions under the will. He is appointed by the testator himself by his will. So testator has to mention the name of such person who will execute the will after his death. Executor has to act like a trustee for the beneficiaries, legatees. Even any such legatee who undertakes to carry out the wishes of testator will be treated as a trustee. So even legatee can undertake the responsibility of execution of the will. Then the meaning of administrator. Administrator. The person to whom letters of administration is granted by the competent court for administration of the estate of any such testator who had not appointed any person as an executor under or by his will. Suppose the testator has not appointed any person under his will as an executor. Then in that case, even any legatee can also undertake responsibility of execution of that will. But suppose there is no consensus among between the several legatees about the execution of that will, and if suppose the matter went to the court for that purpose, when the competent court appoints any person as an executor of that will, then he is known as administrator of the will. The distinction between an executor and administrator is that executor can be appointed by the testator under his will, whereas the administrator can be appointed only by competent court. Then probate. Meaning of probate. When the competent court grants letters of administration, then it is said to be grant of probate. So probate, who grants it? Competent court grants letter of administration concerning the will, then it is said to be grant of probate. Probate means the copy of a will which is certified under the seal of competent court. So it is a copy of a will certified by the competent court. It is the conclusive evidence about the due execution and validity of the will. So when court issues the probate for any will, then it is full and final evidence about the proper execution of the will and about the validity of the will. So obtaining of probate is very essential. Then we will see topic regarding attestation of will, attesting witnesses, attestation of will and attesting witnesses. Attestation of will is a mandatory, that is compulsory formality for a will. It is compulsory. It is absolutely necessary that attesting witness should sign the instrument, that is document of will. When the attesting witness signs the document of will, it is called as attestation of will. So it is necessary that attesting witness should sign the instrument of will. Law says that a will must be attested by at least 2 witnesses. At least minimum 2 witnesses. But it is safe practice that don't restrict to only 2 witnesses if more than 2 are available. For instance, if 3 or 4 persons are available, then make them such attesting witnesses. So law says minimum 2 persons should be there as attesting witnesses, but for the purpose of further security, we can also have more number of attesting witnesses. After the death of the testator, many times dispute arises either among between the heirs of that person and the legatees, or amongst between the several legatees. Many times when matter goes to the court, dispute goes to the court, then the person who do not get any legacy or benefit or property under the will, generally he take defense that that will is invalid. It is invalid. So many times dispute or litigations in the court get created regarding due and proper execution of will and regarding its validity after the death of the testator. So before giving any effect to such will, it is necessary to prove its valid execution before the court. So the person who is a legatee or who is executor or who is beneficiary of that will, he has to prove before the court that said will of the testator is validly executed. Because the testator himself is now dead, he cannot be called now as a witness before the court to prove the due execution of his will. Therefore, now after the death of the testator, everything depends upon the attesting witnesses through whom only such due execution of will can be proved. So it is the attesting witness with the help of whom will can be proved to be valid. While selecting the person as attesting witnesses, a credibility or reliability of them is very important factor. So it is a choice of the testator to select the person as attesting witnesses. A testator selects a particular person as attesting witness because he has a trust in them. Testator believes that after his death, those attesting witnesses will prove the will in the court of law. So credibility of those attesting witnesses is very important. Besides that, the age factor of such attesting witnesses is also important. Generally, such person should comparatively be of the younger age than that of the testator. Otherwise, it may happen that such witness dies before the testator. So generally, when people become of old age, they think about making of will. So when any old age person makes a will, then it is better to have some younger person than him as the attesting witnesses. Otherwise, there is a risk that witness died before the testator. Besides that, such witnesses must also have capacity to depose or to testify, that is to face the examination before the court. It is in the court proceeding one has to prove the execution of the will. And for that purpose, attesting witness have to attend the court. And they have to give evidence through oral evidence. Orally they have to depose before the court. Orally they have to make statement before the court for the purpose of evidence. So attesting witnesses must be such persons who are able to face the examinations before the court. Law says that there should be at least minimum 2 attesting witnesses. Each witness must have seen the testator sign the instrument of will. So what they will give statement before the court? They have to give statement before the court that they have seen that testator had signed the document of will in front of them. So each witnesses must have seen the testator sign the instrument of will. Law says there should be minimum 2 witnesses. So if any will, there is one on any will there is only one, for any will there is only one attesting witnesses, then that will is invalid will. There has to be minimum 2 witnesses. Attesting witnesses need not know the contents of the will. Means contents, testator gives his several properties to several legatees. So which property is given to which legatee, it is not necessary for the attesting witness to know it. His role is restricted. His role is restricted only to the fact. Which fact? Testator signs the document of will in his present. Therefore, the proof of attestation does not mean that the attesting witness also knew the contents of the will. Not necessary. The law requires that there should be minimum 2 attesting witnesses. Why? Because suppose something is happened after after the death of the testator, when matters goes to the court, when dispute arises regarding validity of that will, then in such situation at least one witness should be able to give evidence before the court regarding execution of will. And suppose even if single witness, attesting witness, proves the signature of the testator, then law says it is enough. Since the wills are treated as magnificent documents, they should be free from all suspicion. So many a time when dispute goes to the court regarding will, the person to whom testator has not given any property, or because of that will, those heirs who are get deprived of getting property by succession, they generally take defense that said will is suspicious will or bogus will. Therefore, the law says that any bequest which is given to any attesting witness or to his or her spouse shall be null and void. When the issue raised before the court regarding doubtfulness of the execution of will, then in that case everything depends upon the attesting witness to prove the due execution of the will by the testator. And therefore, it is expectation of the law that witnesses should not be biased witnesses. They should be independent witnesses. Therefore, no bequest should be given to any attesting witness or to his married partner, that is to his or her spouse. And if any bequest is made in favor of any attesting witness or in favor of his or her spouse, then law says that such bequest is null and void. However, this rule regarding not giving any bequest to the attesting witness, otherwise it become null and void, this rule is not applicable to the wills made by any Hindu, Sikh, Jain, Buddhist. Nevertheless, it is always safe practice to avoid giving up any bequest to the attesting witnesses. Why? Because the person who is challenging the will, validity of the will, he may contend that attesting witness is speaking false. He is giving wrong statement about the execution of will. And why he is giving the wrong statement? Because testator has given some property by his will to that witness. Therefore, that witness is biased witness. And so as to avoid such thing happen later on, it is always safe practice to avoid giving of any bequest to the attesting witnesses. We will continue discussion on this topic further in the next video part. Thank you.